Okay, so our next speaker, my wife and I met this woman on a very good recommendation dealing with our will and our estate planning. Through that process, it sounds like a real simple thing, but she opened our eyes to quite a few things we took for granted. So we thought it'd be important for her to share some insights. This is Rebecca Geyer from Geyer and Associates.
Oh, yeah, that would be good. Thank you. Well, as Josh said, there are a lot of intricacies that come into planning for anyone who might have special needs. Most of the laws regarding this area all have to do with public benefits that you may have an individual you want to retain eligibility for. And if you leave money outright to that individual, whether they're a minor or as an adult, you may wish the money benefit them for their future needs. But if you leave it to them outright, it may jeopardize their eligibility for programs that they might currently receive funds from or health care from, including things like Medicaid and SSI. So what I'm going to do today is, I know everyone probably feels strongly about making sure their family members have what they need. I want to give you kind of a primer on public benefits and what you should be thinking about as you consider doing planning for any child or any adult really with special needs. So we're going to start there. I know people are coming from different states. So the good news about this is most of the laws we're going to talk about today are federal, which means they exist in all 50 states. They're not just here in Indiana, for example. We're also going to talk about different documents that you should be looking into. So I'm not knowing where everybody's education is on this subject. I thought I would begin at the beginning and start by just giving you a little primer on federal benefits. So the first thing that we're going to talk about is what types of federal benefits exist. One of the things that's really difficult, I think, for people to get their heads around is what do all these acronyms mean and what different federal benefits exist for their loved ones. And this is really difficult not only because there are many, but because so many of them have the same name. So the first one I put up here is Social Security disability income. The next one is supplemental security income, Medicare, and Medicaid. So as you can see, they have a number of different names, and they may all apply to your loved one at some point during their lifetime. So I'm going to talk about the requirements for each of these governmental benefit programs. The last thing I put on here, Medicaid Waiver, which is a program that exists now in all 50 states to allow funds under the Medicaid program to be used for disabled individuals in at-home or school-based settings or in an assisted living or group homes, as opposed to traditional Medicaid, which was either health insurance-based or care in a nursing facility. So we have come a long way. We now have care at all different levels under the Medicaid program. Okay, so let's start with Social Security disability income. Most people, if you're dealing with children who have had a disability from birth, are not going to be dealing with a situation involving SSDI. Many people think I want my child to receive Social Security disability benefits, and that is SSI if you are disabled and do not have a work history. Social Security disability income applies to individuals who do have a work history and have paid into the Social Security system, and it is not a means-based governmental benefit program, meaning you don't have to worry about how many assets you have in order to qualify for this type of benefit. You just have to have a disability that is expected to keep you from working for at least 12 months, and you have to have paid into the system in order to receive this benefit. For most people, if you're looking at getting a disability check for a disabled child, what you're looking at is supplemental security income. And that gives cash assistance to people with limited income and resources who are either over the age of 65, blind, or disabled. Most of your children would not be eligible for SSI until they reach the age of 18. And that's because until they reach the age of 18, their income or eligibility for SSI would be based on your earnings and household income. And when they reach the age of 18, that's no longer true, even if they're still living with you. SSI is a means-based benefit. In order to be eligible for SSI, an individual may only have $2,000 in what we call countable resources. So this is so important to understand because if you want to leave money to benefit your child and they're an SSI recipient, and you leave them a lump sum which increases their net worth to more than $2,000, they will lose their SSI eligibility, which means they will no longer receive a check. So it's very important to protect the eligibility for SSI income. I want to talk a little bit about Medicare. Medicare, many adults think about this because when you're age 65, you're automatically eligible for Medicare in the United States if you've paid into the system or your spouse has, and that's health insurance coverage. But what you may not know is if you are considered to be disabled by the Social Security Administration, so you're receiving either SSDI or SSI, you're automatically eligible for Medicare as a health insurance form 2 years after you're considered disabled. So this is extremely beneficial for disabled individuals because it gives them health insurance coverage, which is some of the best in America at the least expensive cost. So Medicare may be not something you're concerned about now if your children are minors, but it may be something that they become eligible for once they're eligible for SSI at age 18, then they would become eligible for Medicare 2 years after that disability determination. It can be supplementary. The way it works typically is Medicare becomes the primary bill, then your health insurance becomes the secondary for billing purposes, and then typically in most states, Medicaid, which we'll talk about in just a second, is the payer of last resort.
Can you hold on a second?
Yeah.
Well, the reason why I ask is because I think my daughter's on Medicaid, and so that's a supplementary to my primary insurance.
Yes.
For as long as I carry that.
Correct.
But at any time, she can go under Medicare?
If she's considered to be disabled by the Social Security Administration, so if she's on SSI, she could qualify. I don't know, how old is your daughter?
28.
Yeah, so and she's on SSI now?
Yeah.
She should already be eligible for Medicare if she was considered to be disabled 2 years ago, at least 2 years ago.
Okay.
And they'll auto-enroll her.
Oh, because, and then I don't have to worry about even keeping, if I change insurances or anything.
You don't. She would have insurance through Medicare with Medicaid as a backup.
Essentially, my understanding is that it's your, if you're eligible both for Medicaid, Medicare, and a private health care program, for all of those things, it's your choice what you want to be in first place.
Yes, that is true. So it's not as to what you want to be in first place. Medicaid, which is funded 50% in most states by state tax dollars, is always going to be the payer of last resort. That said, it is your choice as to whether or not you want to be on Medicare or pay still for a primary health insurance policy. The problem, unfortunately, with Medicare and Medicaid in most states is that although you have health insurance coverage, not all doctors accept payment under those programs. So you may choose to have a private health insurance policy because that is what your doctor accepts.
Right. Or you may choose the opposite because the private health care plan that you've chosen doesn't include the drugs that you want to use in the formulary.
Absolutely.
I got one. When I started on Medicaid, when I got age 65.
That's Medicare, by the way, not Medicaid.
I mean Medicare.
Mm-hmm.
They switched my son from Medicaid to Medicare as primary.
Because you were eligible and he's earning based on your record.
Yeah, and they switched it from SSI to
DI?
SSA, I think.
Because he can pull, once you became full retirement age, he may be eligible to pull off your retirement record and receive more as a disabled dependent child than he does on SSI. Because what he gets under SSI is pretty limiting. It's $733 a month. So you can get more if you can pull off a parent's record. And one of the things that I will tell you, I didn't include this in my materials, but if you want to make a note, if you have a loved one who is receiving SSI or you're applying and you're wondering how to get the best coverage, is SSI the best we can do, or can he or she pull off of a parent's record? What you want to do is make an appointment through the Social Security 1-800 number with an individual called a benefits specialist. You do not want to go to your local Social Security office and talk to the person at the front desk. They have a limited access to the full records as to which your child, or you for that matter, can draw on in terms of records. So you want to make an appointment with the benefit specialist, and they can run the numbers and all of the Social Security profiles as to which a child or even an adult can pull Social Security benefits from and determine what might be the best amount that your child or you could get in retirement. Medicaid is different from Medicare. Medicaid is a state-sponsored and federal-sponsored health care program. It is also a means-tested program. It is actually funded typically about 50% in each state from federal dollars and 50% from state dollars. And the rules for Medicaid are based in federal law, but because it's funded by each state as well, every state has their own set of rules regarding Medicaid. So what I would know about Indiana Medicaid might not be true in Illinois or Michigan, because every state has their own laws with regard to Medicaid. There's only one exception, and that is the rules that they have cannot be more restrictive than the general rules set by the federal government. So there may be differences from state to state, so it's always important if you have questions about Medicaid that you seek out help from someone in your state, because the laws are state specific. Medicaid is health insurance for individuals typically who have low income and assets. It is means tested, which means you have to meet certain income limits and asset limits. Not all states are tied to SSI rules. So here in Indiana, for example, we are tied to SSI rules, which means just like SSI, an individual who applies for Medicaid may only have $2,000 in what we call countable resources in order to be eligible. Other states have a slightly higher maximum, $3,000. Some states have $1,500, but it's not much. So if you have a child who needs health insurance coverage or care under certain waiver programs, maybe they need an aid in school or they need transportation, they need to live in a group home, those programs are typically found under the Medicaid platform. So this is a very important one to understand. In most states, children do not have to wait until they're 18 in order to qualify for Medicaid. They can apply based on their own record and receive care through Medicaid. So that's an important thing to note, which is different from SSI, which you would not receive typically until you're 18 as a disabled child, because you're going to be considered to be part of your parents' household. So if an individual meets the financial eligibility requirements for Medicaid, in a state like Indiana, which is an SSI state, if they're considered disabled by the Social Security Administration, we automatically, meaning they get SSI, we automatically enroll them in Medicaid in Indiana. We no longer make people go through two separate application processes. There are a number of states that follow that approach, which has made it a lot easier for families instead of having to go through two separate application processes. And if any of you have ever been through Medicaid or SSI, it is not a walk in the park. It's not easy to get information. It's not easy to get somebody on the phone to help you, and it can be difficult to maneuver. And there's things to do on an annual basis to make sure those benefits stay in place. In Indiana, these are our Medicaid waivers. In every state, we have different types of Medicaid waivers, but I wanted to make sure you were all aware of the concept of waiver. I brought it up earlier. Over the years, the states and the federal government have realized that not everybody who is disabled or who is an older adult needs care in a facility. And as a result, they provided funds through Medicaid to allow for people to remain as independent as possible, and it allowed for funds to be used to provide in-home care, care for individuals to go to school, care in group settings, in certain work settings. And those benefits are all found under waiver programs. In every state, they're named something a little different. These are the ones we have here. By the way, we got all of our waivers were all renamed a few years ago, so that made things a little bit more complicated. But if you are wondering what type of benefits are available for your child, don't assume that it involves having to go somewhere else separate from your home, because now we have wonderful programs that really allow for individuals to remain autonomous and independent as long as possible through the use of supportive services. Okay, I mentioned this already, but whose assets count for the program differs for each program. After age 18, for all programs, typically the parent's assets do not count in determining whether or not a disabled individual is going to be eligible for either SSI or Medicaid. In the event, though, that they are applying for Medicaid, typically in most states they can apply even when they're under 18. There is one thing I want to bring up because a lot of people are unaware of this and it can cause a lot of problems with special needs planning. If you have a situation where you and your spouse are no longer married and you are required to pay child support payments, and it is not set up to go into a special needs trust for your disabled child, when they reach the age of 18, that child support payment is considered to be theirs, and it will make them disqualified from SSI if it is not appropriately tied to a special needs trust. In the midst of divorce planning, you can agree to have child support paid into what we call a third-party special needs trust, which is one set up by parents or other loved ones. In the event you discover this because all of a sudden your child has lost benefits because you didn't know this, which unfortunately happens a lot, then the child can remain eligible for SSI if the support benefits are put in what's called a self-settled special needs trust, and we're going to talk about that next. So I bring this up just to make you aware that if you know anyone with a special needs child who's going through a divorce, child support can have big implications in terms of governmental eligibility for benefits. Okay, so we're going to talk next about some things that are typically used to help us plan for individuals with special needs. And the most important concept we're going to talk about today is probably something called a special needs trust. We're also going to talk about assets and income and how they relate to that special needs trust. And in-kind distributions, meaning how you dole out money to your disabled child and how that might affect benefits which they receive. Some of the concepts that are available under SSI are food, clothing, and shelter. If any of you have a child who's on SSI, you know that one of the things that the Social Security Administration says is they're going to award payments to an individual for SSI to ensure they have enough funds for food, clothing, and shelter. The assets you may wish to leave a child are really supposed to supplement that. But it can cause a reduction in the amount of money they receive for food, clothing, and shelter if you don't plan properly. So we're going to talk about that as well. Okay, what is a special needs trust? So there are really a few types. There's third-party special needs trusts and what we call self-settled special needs trusts, and we're going to talk about each of these. Special needs trusts were designed under a program called OBRA 93. That was an act passed in Congress in 1993, and it established special needs trusts which basically allow an individual to receive money or to invest money even if it already belonged to them and maintain eligibility for governmental benefits. Congress recognized that individuals with disabilities are going to have needs and that their governmental benefits may not be sufficient to meet their needs for their lifetime. So they wanted a way for families to benefit their loved one, but doing so in a way which would not jeopardize their eligibility for governmental benefits. And that's where we got these trusts. So one is called a D4A. These all refer to the section of the law, and that's for under age 65 individuals. Those are called self-settled special needs trusts. D4B is what we call Miller Trust, which you typically use with the Medicaid program. D4C are called pooled trusts. And they're all applicable to Medicaid and SSI, and we're going to talk about each of them. I will touch a little bit on pooled trusts today. All 50 states have organizations which sponsor what's called a pooled trust, and it's important that you know that they're there as a potential resource, which we'll talk about in a little bit. So we're going to talk first about D4A trusts. So many of you may have a child who has received an inheritance, and there was not proper planning done ahead of time. Or sometimes children have money because they work and they have assets which accumulate in their name above $2,000, and it can cause their benefits to be in jeopardy. Or sometimes individuals are injured in an accident case and they receive a settlement. Well, what happens with those funds? A D4A trust was designed to allow individuals who are disabled with assets above $2,000 to place those assets in a trust. And by doing so, they remain eligible for SSI and Medicaid, but they can use those funds to supplement what their governmental benefits are not providing. The main difference between this trust and what we call third-party special needs trust is that D4A trusts or self-settled special needs trusts come from money that is already considered to belong to the disabled individual. So this isn't money that you would be leaving your child in an inheritance. This is money they've already received, either by virtue of a settlement, the fact that someone didn't plan properly and left them an inheritance, or money they've earned and it has just accumulated beyond a certain point. In order to establish one of these trusts, you have to do it in court typically, and it has to be signed by a judge and established either by a parent, a grandparent, or a legal guardian. Right now, it is not possible under law to have the disabled individual himself or herself establish this D4A trust. You would have to do it, or the guardian or a court would have to do it in order to get it established. But what happens is that if the individual, let's say they have $50,000 there, if they establish this trust, they can place the assets in the trust and they will maintain governmental benefit eligibility. The only thing that is different with this trust as opposed to a trust that you might set up for a loved one, first of all, they have to be for the sole benefit of the disabled individual. They have to be under the age of 65, and this is the big one. Because the government is saying that these individuals have money and they're going to let them keep that money, there has to be a payback provision in these trusts, which state that upon the disabled individual's death, any funds which remain in that trust must first go back to the state to reimburse them up to the amounts they paid for that child's health care. So you have to have a payback provision in this trust in order to make sure that the person would remain eligible for governmental benefits. So ideally, if we're talking about you leaving assets to your loved ones, we don't ever want you to give it to them outright, so they would have to establish one of these. We don't want you to have to go through a payback provision, so instead we'd prefer you use what's called a third-party special needs trust. And almost everything is the same about the two trusts, except those don't have to be created by a court order, and there's no payback provision when a third party sets it up personally, and that the money comes from the third party. It's not considered the individuals. We're going to talk about that in just a minute. One thing I wanted to bring to your attention is right now, Congress is considering the Special Needs Trust Fairness Act. This act actually passed the Senate unanimously. You know, it's not easy to get our legislature to agree on a lot these days, but it passed the Senate unanimously just this week. The Special Needs Trust Fairness Act was going to allow individuals themselves to establish these trusts instead of having to go through a loved one or a guardian or a court. So that would be a significant change because since 1993 we have not had that option. So be on the lookout for that. That's going to the House for debate next. Do you have a question?
So is this also known as a self-settled trust?
Self-settled special needs trust.
Okay, and then the payback provision was related to Medicaid?
Yes, it's related to Medicaid. There is no payback provision for SSI, but if most people who were on SSI also received some form of Medicaid benefits, and so what is required is before anyone else would receive any remaining funds in that trust upon the disabled individual's death, you have to have it pay back the state up to the amount that it paid for the individual's care under its Medicaid program.
And since Medicaid is a state by state, is that the universal?
That is universal.
Okay.
So sometimes I'll have people who actually move and have received benefits in more than one state, and it's necessary to have a payback provision sometimes for multiple states.
Okay. Thank you very much.
No problem. Okay. Why would you create then a D4A trust if it has this payback clause? Well, sometimes you do it because you don't have someone who's on Medicaid benefits. They're just receiving SSI, which was a question you just asked. So it doesn't matter if the individual creates the trust because we're not worried about a payback. Sometimes it's because based on Medicare expenditures, the individual received the money, but under Medicaid you pay less for those expenses than you do privately. So it's better to kind of leverage the Medicaid eligibility and do so using a self-settled trust. There's no interest on long-term care expenses under the trust. And the alternative is actually a restricted guardianship account, which is no fun. I don't know if any of you have ever dealt with this, but a restricted guardianship account means that the individual who's the guardian has to go to court and get a court order in order to use funds on behalf of the disabled individual every time they need it. as opposed to having money in a trust like this where you have a trustee and they can spend funds automatically without needing a court order. Ideally, though, if you are a parent doing planning, you're never going to have to worry about a self-settled trust because you are going to leave money from you in a third-party trust which has no payback provision. Yeah. Oh, about how you would plan? Oh, I'm not sure which part you missed. Oh, the restricted guardianship account. So if you leave money, in Indiana, for example, if you were to leave money outright to a beneficiary worth more than $10,000, and the beneficiary, by the way, doesn't have to have a disability. They could just be a minor, for example. We require the funds to go into a guardianship account with someone else managing it. This is true in almost every state, although the amount of money varies. What happens when it goes into a guardianship account is the person who's appointed as the guardian, in order to use the funds, has to go before a court and request permission to make a distribution from the account to pay for the ward's needs. Or they have to spend the money and then go seek reimbursement from the account, which is a total pain. I'll tell you the #1 way that this happens, because I bet if I asked you right now and I went around the room, how many of you own life insurance policies or a retirement plan? Almost all of you. How many of you have your children listed as a beneficiary on those? Okay, so if you take away nothing from what I say today, the #1 thing I want you to remember is do not name your children, especially your disabled children, as an outright beneficiary on your policies. It is a common mistake. 99.9% of the people I meet with leave their children as a contingent beneficiary or as a beneficiary on retirement plans and insurance because that's who they want to receive the funds. What you really want to do is establish a trust and make the trust the beneficiary, especially if they're disabled and you want them to maintain their benefits. And we'll talk about that in just a minute. Okay. Third-party trusts, then, are the big one for most people who have children with a disability. If you want to put your estate planning in place and you're concerned about leaving funds to your disabled child, you want to make sure they have adequate funds to support them in the future, but you don't want them to become ineligible for governmental benefits, what you're going to do in your planning is establish a third-party special needs trust. Third-party just means someone other than the disabled individual is the source of the funds. So you or your other family members are going to create a trust. And this trust can stand alone, meaning you can have a document that exists and you can put money in it right now. Or it can just be funded at the time you die, meaning it's part of your will or it's part of a revocable trust. And when you pass away, assets you want to benefit your disabled child would go into it. All the money in this third-party special needs trust is going to be used for the benefit of the disabled beneficiary. But when they pass away, there's no payback provision because it was never considered to be the individual's money. So that's a significant advantage. It means you can leave remainder beneficiary in there. If you want any money which is left over to go to other children you might have or to a charity or someone else of your choosing, you can do that because you're not required to reimburse the state for any funds they paid on behalf of your loved one's care. So this allows you, as I said, to provide for the needs of an individual with special needs, provides benefits without affecting their eligibility because they are never considered to be the owners of the funds in this trust. It does not jeopardize their eligibility for SSI or Medicaid. And it can be used by all interested third parties, meaning you can set one up at the time you pass away or during your lifetime, but other people can leave money to it to provide for the benefit of that child. Okay, so what do you want to consider when you're creating a special needs trust? Well, obviously you're doing this for the benefit of your disabled child, but other things you might consider is who's going to be the residuary beneficiary? Who else would you want to benefit from these funds in the event something happened and there was money still left in there? A third-party trust can be simply fully discretionary, meaning that you don't have to provide that the trust has to pay out money to your disabled child for specific things. You can put someone else in charge and allow them to make distributions as to what they feel the individual needs as they age. It's irrevocable, So when you set up a third-party special needs trust, you're not going to go back and change it. Typically, these don't go into effect until you pass away anyway. But you can put parameters in there to amend it under certain circumstances. So maybe the trustee needs to be changed, or maybe the law changes in some way, and you want to provide a procedure to ensure that the trust complies with the new law. So we can amend them in certain circumstances. One of the biggest things to consider, though, is who will be the trustee of the trust. And this is a really big concern, not only because you want to make sure that person's going to be there for the long run and know what your child needs, but because they need to distribute funds from this trust in such a way that it will not cause that child to become ineligible for governmental benefits. The creation of the trust and the trust funds sitting there are not going to be a problem. It's how the funds are distributed that could be a problem. And we're going to talk about that in just a minute. I always tell people one thing you need to consider is the trustee familiar with governmental benefits? Okay, so things to consider when you're selecting a trustee. Do you want to have a corporate trustee serve or a family member? A corporate trustee is a bank or an agency that can serve to manage funds for the benefit of an individual. Some people really like the idea of having a third party who's familiar with handling money serve. But when you're dealing with individuals with disabilities, a lot of times people don't feel comfortable with that because that bank may not know your family. They may not truly understand the needs of your child. And so a family member seems more appropriate. There are actually ways where you can appoint a corporate trustee if they're more familiar with the rules regarding governmental benefits and still have a family member be an advisor. But it's important that you go to someone who understands these areas of the law who can direct you on that. What type of assets are you going to hold in the trust? What kind of funds are you leaving for the benefit of your child? Is it going to be easy, like life insurance proceeds or cash? Or are you intending for more complex assets to go in there, like a house, or maybe I have a lady with a child with special needs and her family owns multiple rental properties that she wants to make sure are preserved for the benefit of her disabled child because they provide a nice income that can be used for her benefit. So assets can be an issue to consider because it might make things more complex in administering. Financial ability and experience. Sometimes I meet with families and they tell me, you know, my sister is so great with my child and I feel very comfortable having my child live with her in the event something happens to me, but she's terrible with money. And that happens a lot. I see some people shaking their heads. This is not an uncommon situation. So in that case, sometimes it's better, even if you have your child go under guardianship with someone else, maybe you want to consider having someone else or an institution control the money. What about the individual's willingness to serve? Sometimes we have someone in mind who we think we would be a good choice for trustee, but they're not really willing to serve. So it's really important when you're doing this type of planning to make sure you discuss with the person you would like to name as trustee their willingness to serve and whether they understand the responsibilities. How are they going to be required to dole out money to the disabled individual? You know, how are they going to need to invest it? What kind of requirements do they need to file in terms of making sure the individual remains eligible for SSI or Medicaid, as an example? Finally, understanding your wishes is a big one. One of the things I often recommend that people do is write a letter to the trustee explaining what their thoughts are on their child's needs for the future and what they want to see accomplished for their child. Because remember, if something happens to you and you're not around, you can't give that guidance. And you are the best people to understand what your child needs and how you want them taken care of in the future. So making sure you leave clear-cut direction, understanding your wishes as to how you want the money utilized and spent is very important. Succession planning is also important. So maybe you do want to name a family member now, but what if they pass away? Do you have a backup person named? That is something else you need to consider when you're doing this type of planning. I did not include a slide on this specifically, but I wanted to talk about this here, and that is, I mentioned earlier the idea of a pooled trust. We've talked about establishing things like self-settled trusts or third-party trusts. One option that exists in all 50 states is a pooled trust. There are agencies which exist in all 50 states to provide options for individuals with disabilities. In Indiana, our pooled trust is called the Arc of Indiana. What a pooled trust does is that it recognizes that many individuals have disabilities, and they may not have someone who is available to manage funds for them who understand governmental benefits. So pooled trusts exist, and they have a pooled trust that is a self-settled trust and one that is a third-party trust. And this pooled trust agency serves as the trustee. And one of the reasons a lot of people like them is because this agency specializes in understanding the rules and reporting requirements associated with SSI and Medicaid. And as a result, they can serve as trustee, and they know how to distribute money and do the annual reporting and file taxes in such a way that it would not cause the individual to become ineligible for governmental benefits. These pooled trusts exist, and they charge a much smaller fee than a traditional third-party trust, and they typically allow individuals to name a family as a key person who would consult with the ARC or the other pooled trust agency to determine how funds should be used on behalf of that individual. So pooled trusts exist. The reason they're called pooled trusts is that everybody who has an account with them has their own account, but the agency pools all the money together for purposes of investment so that they can get an overall higher rate of return for each individual's account. That's why it's called a pooled trust. Yes, sir. It can. Each pooled trust will have slightly different language in it. So here at the ARC, the Self-Settled Special Needs Trust will, of course, say that the ARC has to give money back to the state, and then you can leave money. Sometimes there'll be a requirement that you pay the ARC agency or the pooled agency a small fee for the services they've done, and then you can name residual beneficiaries.
Thank you.
No problem.
But excuse me, I had another.
Yeah, go ahead.
It's me. We're a pair. So what's the downside to the pooled trust?
Some people just don't, they want a family member specifically in charge, or they're concerned that the pooled trust won't pay out as in the same manner that you would typically do. I think it's important, if you're considering using a pooled trust, that you go and meet with them and discuss how they distribute funds. I've found them to be great. I have a case I was working on just this week involving a client of mine who is a disabled adult who lives in a group home. He was injured, unfortunately. He was already disabled, but injured by a care manager. And he has funds on tap at the ARC, and we've used it for all kinds of things. We just used it to buy him a new TV and a new washer and dryer and a couch to make him comfortable. We've bought clothes. We've pre-planned his funeral, spending money to go to the movies, all kinds of things from that account. So some people don't like the idea of using a third party. They want it with the person. Other people feel really comfortable because you anticipate the agency will still be there and they're familiar with the governmental benefit rules.
So, and I don't want to take you off track of what you're doing, but one of the things that also the tax implications seem somewhat complex. We have invested in qualified retirement plans, and just have come to understand that there's a tax impact there that we just weren't aware of when a special needs trust is in play. And so the whole tax thing just seems really confusing to me as well, and I wonder if the pooled trust helps with that.
It can. And so yes and no. I'm going to simplify that down because it's a good point to make. Many of you might have retirement plans from work that you have been contributing to. And most retirement plans, qualified plans, are tax deferred, meaning you're not required to take a distribution from them until you reach 70 and a half. And if you die and you leave those monies to your spouse, they're not required to take distributions until they're 70 and a half. But if you die and you leave those monies to anyone else other than a spouse, that individual is required to begin taking distributions the year after you pass away. They don't get to wait until they're 70 and a half. They have to start taking distributions right away. If it's set up properly, they can stretch those distributions out over their lifetime, and I'll explain what this means. Let's say you leave money for a child, and at the time that you pass away, your child is 30, and their life expectancy, let's say, is 46 years. They would be required to take out 1/46 of the account every year and pay taxes. Where that gets complicated is if you have that retirement account pay to a special needs trust. Because although we look through the trust to the oldest beneficiaries, which would be the disabled child, to determine how the funds are paid out, we don't necessarily want to distribute the funds once a distribution is made outright to the child. And if we don't do that, then trusts pay income tax at a higher rate than individuals. So what I have done with a lot of my clients in those situations is they like the idea of a pooled trust. The pooled trust prefers cash. They don't like to manage retirement plans. So you might have a third-party trust set up in your estate planning, which can take the minimum distribution, and they turn it over to the pooled trust. So that's a potential option. That doesn't mean that there might not still be some income tax concerns related to that. We try to minimize that, but that is a potential way that we handle that.
I have one question.
Yeah.
I did set up a living trust for my son, and it just has like, it's called the My Name, you know,
sure.
living trust. But I don't know which one of these it falls into.
That would be a third-party trust. So you have a living trust that's for your lifetime, and upon your death, it goes into a trust for him?
Well, his name isn't mentioned anywhere.
No. Even upon your death?
Right.
Well, it may just be a trust for you then. You might check and see if at your death it flows into a trust for him. That's typically what should happen. And that would be a third-party trust.
The house is in the trust name.
And then upon your death.
Nothing is in my name.
Right, it's in the trust, and then the trust document would read that it goes into a trust for his benefit when you die.
Right.
Okay, I just want to talk briefly about the role of the trustee. The trustee, when you name someone to serve over the trust for the benefit of your child, their role is to act as a fiduciary, meaning they have certain guidelines they must follow. They can't take any sort of private advantage of those dollars. They're not supposed to be using it for their own benefit. When you're a fiduciary, that means you're held to a higher standard, and you're using those funds solely for the benefit of the beneficiary of the trust. No self-dealing. That doesn't mean, unfortunately, that it doesn't happen sometimes, but that's the rule. No self-dealing. You're supposed to make distributions in the best interest of the beneficiary, and you're held to a prudent standard, which means you don't want to serve as trustee and invest all the money in a really high-risk stock, because the goal of that money is to be there long-term for the disabled individual. So you're supposed to invest the assets prudently. So it's really important that the trustee understands this as well. Okay, I just want to talk about how you administer these trusts. I'm not going to talk about this in detail, but I want to give you a little bit of an idea. Sorry. Okay, the first rule when you set up these trusts, like I said, if you die and you have the money go into a special needs trust, that's fine. That's not going to jeopardize the individual's benefit. But if your trustee starts giving the individual cash, that's a problem. Because when you make distributions of cash, if it accumulates in their name, it could put them above $2,000. And most state Medicaid plans also have an income limit, which means it could increase their income if you're making a standard distribution to them. So you don't want to have the trustee make cash distributions to them. Also, if you use the money instead of their SSI to pay food, clothing, or shelter expenses, it may cause a reduction in benefits. SSI has a rule that says if somebody else is providing food, clothing, or shelter, then the beneficiary's SSI can be reduced by up to a third. You see this if you've got a disabled child who lives with you as an adult. You're providing them with their home and you provide them with food, they're not going to get their full SSI benefit. They're going to have a reduction because SSI says, well, you are providing that support. They can't reduce it by more than a third, but they can reduce it. So if people start giving cash to a disabled individual, it could reduce their SSI benefits. They do have ordinary fiduciary obligations also in administering this, meaning they have to follow prudent standards. So how do you make distributions? Well, you can provide funds in a number of different ways. What a lot of people like to do is to provide their disabled individual with a credit card or a prepaid card that the trust buys that allows them to go out and buy expenses that they may need. And it can provide for entertainment expenses, education, counseling, therapy, companionship, adaptive aids, transportation, medical care, funeral expenses, gifts for others, travel. It's really comprehensive. TVs, whatever you can probably think of that someone might need, it's pretty much covered. Many people will do gas cards, for example. They'll purchase that if the disabled individual can drive so that they're not giving cash, but there's a way to make a distribution. You can, once SSI has been expended for food, clothing, and shelter expenses, you then can use the trust funds to pay for expenses that the SSI didn't cover. So let's say your loved one gets the full SSI benefit. Well, that's still under $800 a month. That may not be enough for them to live on a monthly basis, and they may need money in the trust to pay for utilities or other expenses. What you want to see happen is that the trust pays those expenses directly instead of the individual receiving money to pay those expenses. So the trustee's job would be to pay those expenses on a monthly basis. What about residents? Many people ask, can I leave money in trust to purchase a home for my child? And the answer is yes. The trust can also own a home. There are some different rules which may apply if someone else lives in the home with them, but that is also an option. Okay. One thing I wanted to point out, and this is why I asked you, who do you have listed as the beneficiaries on your retirement plans and your life insurance policies? It is not enough to go to an attorney and say, I want to put a third-party special needs trust in place. I know if I have this document, everything's going to be okay. If your assets are not coordinated with the trust you establish, the paper is not going to help you. Many people think that all their assets pass in accordance with their estate planning, and that's not the case. The title. So if you own an account jointly with your disabled child, or with a spouse for that matter, whoever the joint owner is receives that asset. It doesn't matter what your will might say, the title says where it goes. If you have an asset that passes by beneficiary designation, like a life insurance policy or a retirement plan, and you've left your child as an outright beneficiary, it will never go into the trust for that child's benefit. So you want to not only create the trust, you want to properly coordinate your assets to the trust. So you mentioned you have a living trust and you have your home in it. Same thing applies here. We would want to deed real estate to the trust if that's something that needs to go in it. Make sure that the beneficiaries on life insurance policies and retirement plans are properly updated to provide for the special needs trust. We may need to retitle bank accounts or brokerage accounts to coordinate things with the trust. So that is the second piece of the puzzle. It's not enough to have the document in place. You have to make sure your assets are properly coordinated with the document. Okay. One of the things you asked about a little bit ago was income tax implications. I'm not going to spend a lot of time on taxes. Nobody likes to talk about death and taxes for too long. If you have a self-settled special needs trust in place, meaning the money already was considered to belong to the disabled individual, that trust that they set up is held under their Social Security number. They pay taxes on their same 1040 return that they always have. If you set up a third-party trust with your money for that individual, that is its own tax-paying entity. It has to have its own tax ID number through the IRS and file a separate tax return. It does not file a separate tax return, though, until it's funded. So if your third-party trust is part of your planning when you die, it won't have a tax ID number of its own until after your death. So I just wanted to point that out. An accountant can do them. Sometimes I do some of the returns for my clients. Instead of a 1040 form, which is what individuals use, trusts or estates use a form called a 1041. Okay, I want to bring your attention to one other concept because we spent a lot of time talking about trust, and we have a new concept which I believe as of this legislative session is now available in all 50 states. We have a new act called the ABLE Act. I don't know if any of you have ever heard of this. An ABLE Act account is kind of like a 529 plan, but instead of being used for education expenses, it's for disabled adults to use for disability expenses, what we call qualified disability expenses. In Indiana, we just passed this in April. It went into effect July 1, although we're still trying to figure out where all these accounts are going to be established. But it allows an eligible individual with disability to have an account similar to a 529 plan, which they control up to $100,000 and not jeopardize their eligibility for governmental benefits. So unlike a trust, which has to be controlled by someone else, you're allowing the disabled individual to be able to manage up to $100,000 in this account, and it will not jeopardize their benefits. So we'll talk about when you would want to consider using this as opposed to a special needs trust. What I like about this is it allows a disabled individual who has the means to control at least some money, some independence and autonomy while not jeopardizing their benefits. So you can only have one ABLE account. You can't have them in a bunch of different places, and they have to be established in the state where the disabled individual lives. And an ABLE account can only be established for individuals who are considered disabled before they were age 26. So if it's a disability, it has to have occurred when they were less than the age of 26. Basically, the amount that can go into it is an annual gift tax contribution. The annual gift tax election right now is $14,000. So it cannot receive an annual contribution of more than $14,000 into one of these accounts, and the maximum it can get is $100,000 over time. Okay, in the event the individual does get more than $100,000 in their ABLE Act account, they will lose their SSI, but not their Medicaid. ABLE account distributions can be used for all the same things that trusts can be used for individuals, but if it's used for food, shelter, and clothing, it could result in a lessening of the SSI benefit. As I mentioned, that can happen before. And one of the things that people like about them is like 529 plans, which are set up for education. Once you put money in an ABLE Act account, it grows tax-free. We don't pay income tax on the money inside it. That's what I said. Earnings on the ABLE account and distributions from the account are all tax-free. If you set one up in your home state and you later move, you can move the account and set it up in your new state, because now almost all states have passed this legislation. And you can roll them over from one account to another. Okay. One of the things that is similar to a special needs trust with ABLE accounts is that although the disabled individual gets to control it, because the money is theirs, ABLE accounts do have a payback provision in them, just like self-settled special needs trusts. So the first beneficiary on an ABLE account would always be the state. After that, you can have other residual beneficiaries. So why would you use an ABLE account rather than a special needs trust? Well, sometimes you've got somebody who receives SSI or Medicaid who works, and their money accumulates in their account to more than $2,000. And you don't want them to have to keep going and establishing trusts and doing things. So this allows them to basically have a bank account that they can put that surplus money in, which they can spend personally at a later date, and it would not cause them to be ineligible for Medicaid or SSI. What if you want to leave somebody a small inheritance? It doesn't make economic sense to set up a big trust, because all you're going to leave this person is $50,000 as opposed to, $500,000. Well, an ABLE account would be a better way to do that, because trusts, if you're going to have somebody in charge, it can be very hard to find a trustee who's not an individual to serve for a very small amount. Sometimes I have family members who come to see me and they have small estates, or they barely wanted to see me. They really don't like lawyers. So they will use ABLE accounts because it's a way to bypass attorneys and set up a way to benefit their loved one without jeopardizing benefits. Parents and trustees who are really interested in giving their disabled loved one more control. So I have a disabled client right now. He's an adult, but he's been disabled since he was a child. He is able to work some. He's somewhat independent, and it just grates on him that his siblings have access to money they inherited from their parents and he doesn't. So one of the ways we solve that is we establish an ABLE account. And now instead of him always having to go to someone to get money on a monthly basis, which he hated, he has this ABLE account with $100,000 in it, and he gets to spend it however he would like. And that has given him some control and independence without having to go to his brother for money on a regular basis. So now we have options. Instead of just special needs trusts, we also have ABLE accounts. Yes?
Hold on.
I'm going to switch. Now I have questions.
Well, back to the concept.
Yeah.
So the money that's in an ABLE account, is it pre-tax?
It's not pre-tax, so it's like a Roth IRA. You're investing the money in it with after-tax dollars, but it grows tax-free.
So when you withdraw, it's
no tax, correct.
And my question is, we're in California, and locally it was passed last year, but I'm still not aware of a way to actually open the account. How do you find out who actually is administering?
I would. So there is a website. I would look and see in California if they have something set up. But I know the National ARC Foundation has been following that in each state, and you might want to look and see. Because one of the things that has been a holdup in all the states is that this legislation has passed, but we haven't designated an actual fiduciary that's going to hold the account. What I've heard talk of is that a lot of special needs pooled trust agencies are volunteering to house the money, but I don't know if that's set up yet.
Is that the way it is in Indiana?
Well, Indiana just now put together its ABLE Act committee, so we haven't decided where we're going to house them yet.
Okay.
We're a little behind the times here.
Thank you.
Hold on.
So my information is that there's actually only 4 states so far in the country who have actually set up their accounts to be operating.
Yeah. They've all now, as of this year, passed the legislation.
Right.
It's just that the accounts aren't operating.
That's right. So it's Florida, Nebraska, Ohio, and Tennessee have accounts where you can establish them. Everybody else is still trying to figure out how to do it.
What happens if one of those pooled trust agencies goes under?
Oh, that is a very good question. So most of them are insured and reinsured, meaning they're not serving and just kind of holding your money and there's no way to guarantee that your money will be there. Most of them are required to carry a bond over the value of the monies that they hold, which means an insurance company is posting a stake in the game so that if they were to go under or lose your money, the insurance company would make whole and then go after that, the agency itself. Rarely that's why they're typically long-standing public 501c3s, non-for-profit agencies, as opposed to individually run pooled trusts, because we don't want to put money at risk.
To the Medicare for individuals that are on their own and they haven't been rolled over into Medicare yet. You made a comment that it's supposed to be automatically done. If they have not done that, what can we do to?
You can call the Social Security Administration. Medicare and the SSA, Medicare and the Social Security Administration are tied to the same database. You can call them and make sure that they have it down, the date of your disability eligibility start date, and see how to go through the enrollment process. And then they'll take care of the enrollment through CMS in order to get that started. But start with SSA, call the Social Security Administration, and they'll get you started from there.
Okay, I'm going back to the Medicare and Medicaid thing too, because it kind of blows me away that our kids are eligible for Medicare, because I was never told that. I mean, she's got the Medicaid waiver, and that's
totally different programs. It's all, yeah.
But why aren't things, because New York State is like crazed about, you know, what they're doing about their Medicaid dollars and stuff, and so is everybody else. This is my dollar that's going towards, you know, your child and blah, blah, blah. But why are not states saying go on Medicare instead of Medicaid? Because it is affecting.
You can go on Medicare, but that's still not going to cover most of the expenses that Medicaid is covering. So they don't cover the same things. So Medicare is really health insurance. So that would cover health insurance needs of your disabled child. It's not going to cover the Medicaid waiver programs that you get in terms of different benefits. So what they cover is different. Medicare, though, is strictly health insurance, hospitalizations, doctor's visits, some prescription coverage.
She can have both?
She can have both.
Okay, then for the insurance part, I mean, not her, you know, not her benefits of the other things. Why aren't they telling people, again, to go to the Medicare instead of the Medicaid for insurance?
Well, usually it's automatically done, so they don't have to, but if you have private insurance, they don't care, because Medicaid is still the payer of last resort, because you've been kind enough to pay for private insurance. So they don't take it upon themselves. They either figure you're going to look for that on your own, it'll auto-enroll, or you have private insurance. So as I said, you can look into that. You can still have private insurance and be Medicare eligible. You're just going to want to make sure that the doctors your child sees take the form of insurance you're using.
So if my child cannot manage her own money, do you not recommend an ABLE account for her then?
I would not recommend an ABLE account if she's not able to manage any funds on their own. This is really for a child that is disabled but has some independence and autonomy. If your child is not able to understand how to use money and would really be subject to the influence of others quite a lot, I would not recommend an ABLE account.
Thank you.
Yes, hi, thank you. This presentation is great. Really appreciate what you're doing. But I'm going back to selecting a trustee because when we look at our family members, there's no way in hell we're going to trust our child, any of those people.
That's okay.
But we do have somebody in mind for a guardian, as a guardian in case we're both deceased. However, that person, as you described, isn't financially capable. So from what I hear you say, it's possible to have a guardian who would take care of our son, our child, but then you can have maybe a corporate trustee handle the money.
Yes, and so if the guardian was going to live with that child, for example, and take care of them, the way it works with the trustee is they will meet with the guardian and determine a budget on a monthly basis as to how much of the trust dollars should be distributed for that child's needs on a monthly basis, and what bills the trust might be paying as a result. And that way it's not required for the guardian to go to the trust all the time to receive money, because a lot of it happens automatically, and then only for your kind of non-everyday purchases do they have to go to the trustee for things.
I'll give you one better. So we have a guardian who can't handle money, but can handle my son. We have somebody else, my brother, who's going to distribute the money, but he can't do taxes, and I have somebody else that does the tax return. So you got to think about that, because there's 3 different roles in what they can do.
Yeah.
You know?
You don't, by the way, have to designate someone specifically to do the taxes. The trustee is always eligible to hire an accountant to do that. You may have had to designate, but not everybody does. Depends on if you want someone specific used or if it's not clear how that's going to be handled. Yeah, you can have co-trust. Correct. You can do what's called bifurcate the roles, meaning some people are responsible for the checking account and other people are responsible for taxes.
What about if he's in a residential facility, but there's still a trustee or a guardian that oversees?
That's fine.
Making sure he's safe in this environment.
So in that case, it's a guardian of the person who would be overseeing his safety and potentially making medical decisions or educational decisions for him, and they're going to do that. But all the expenses related to his care will be handled by the trustee. Then the guardian will actually serve as a spokesperson for your child to provide the trustee with information as to what his expenses are and what his needs are from the trust. There's a lady in the back over here.
There was a phrase you used a couple times when talking about the ABLE accounts that I was wondering if you could clarify.
Sure.
Qualified disability expenses. Is there something really specific that means under the ABLE Act?
It is defined in the Act itself as qualified disability expenses, but it relates to healthcare expenses, adaptive aids, basically the same sort of things that you would find under the federal law with regard to trust. We call it qualified disability expenses as opposed to qualified education expenses under a 529 plan. But it refers to basically all sorts of things that a disabled individual might need, anything from housing and adaptive aids to other things directly related to care and transportation expenses and so forth.
And one other thing, would an ABLE account and a special needs trust be necessarily mutually exclusive?
No, I mean, you could have both. You don't have to have one or the other. Many people will have, like my client who I said hates going to his brother for money because his brother's the trustee of his special needs trust. Well, special needs trust is still in place, but we distributed $100,000 from the trust into an ABLE account for his control.
Thank you.
Sure.
One more quick question regarding a pooled account. My son lives in a current group home, and I'm his current guardian, and they're required to report to me every 3 months what has been paid out of his account. Is all agencies required to do that?
Yes, those who are managing the funds now, there is an accounting requirement associated with that, and the key people are required to receive an accounting. So I actually serve as guardian for one of my disabled clients. He has no family here, and he lives in a group home setting, and I get on a, I think a quarterly basis, a report from our pooled trust. Okay, well, it was a pleasure speaking to you. If you have additional questions, on the front of my slides, I did put my contact information. You're welcome to reach out to me by phone or email.